welcome to Whistleblowing, a Practical Guide. I'm Ranjan Balakamaran with Real Media, as Chris said. Next to me I've got Chris Day, who's just taken the government on and beaten them in a landmark case in relation to whistleblowing. Chris is a doctor. Eileen Chubb, who has a new law called Edna's Law that she's talking about and has years of experience dealing with whistleblowers. Steve Middleton from Bank Confidential, whistleblowing for financial services, and Mary Inman, a whistleblower lawyer from Constantine Cannon from the US. We're going to speak for 4 minutes each about the past, and then 4 minutes about the future. Would you like to start, Eileen? Okay.
I am Eileen Chubb, Bupa 7 whistleblower firstly, the first case to use and be failed by the current whistleblowing law in the UK, Public Interest Disclosure Act. I'm the founder and director of the charity Compassion in Care and co-founder with the late Gavin McFadden of The Whistler. We have dealt with over 8,000 whistleblowers from all sectors, not just healthcare, but education, army, police, probation, prisons, retail, across the board. We're all the same. We've just published a special report. There is no me in whistleblower, and it becomes self-evident what we're trying to highlight here. The case for Edna's Law. Please read our groundbreaking definition of the public interest element that Edna's Law requires to qualify a case as whistleblowing, and bounty hunting completely contravenes this element. All whistleblowers from all sectors should be protected by law equally. To do otherwise would be discriminatory and therefore unlawful, as all should be equal before the law. We research, gather evidence and test everything, and have tested a number of legal firms, including Constantine Noble. Posing as a prospective client, I rang Constantine Noble and spoke to a lawyer under the name of Abbott. I said I was seeing terrible abuse, people being hit and given sedative drugs they were not prescribed, which belonged to other clients who had died or left the home, and the drugs should have been returned to pharmacy. I was immediately asked if the company traded in the US and who was being defrauded by the misuse of these drugs, not who was being harmed by the misuse of these drugs. I said 4 times about the physical assault, but got no reaction, only questions about fraud. See also our evidence on the complete failures of the police safeguarding and regulators such as CQC to protect the public. The whistleblower is not the last line of defence, the whistleblower is the only line of defence. Loss of life and suffering has no value under the US False Claims Act. Bounty hunting is not whistleblowing and should never be referred to as such. I have yet to meet a whistleblower in favour of such a reprehensible practice. You cannot support whistleblowers and be in favour of bounty hunting. If you spent an hour on the Compassion and Care helpline and heard from those who've spoken out and lost everything as a result, heard from families whose loved ones were abused because whistleblowers were ignored, see the integrity of those whose silence cannot be bought at any price, and hang your heads in shame to link the word whistleblower with bounty hunting. Are US whistleblowers more protected? Well, I would ask Chelsea Manning and those whose lives depend on whistleblowers speaking out.
Thank you, Eileen. Chris.
Well, hi, I'm Chris. I'm a junior doctor, and I'm here because we beat the government 1.5 years in the Court of Appeal. But I want to give you this scenario. Imagine you're a junior doctor, or one of the patients being cared for a junior doctor, and you realise that there's something seriously going wrong in the hospital, and you raise safety concerns. These are not insignificant safety concerns. You're the most senior on-site intensive care doctor, and you raise those concerns to 2 NHS agencies, the NHS Trust and the government agency with a formal duty for all junior doctors in the country. Instead of dealing with these concerns that have 2 deaths linked to them, the 2 NHS organisations opted instead to make a load of allegations up to make it less likely for someone to listen to anything that I said. So you can imagine that. That's a terrible position to be in as a doctor. I've got a wife, I've got 2 children. So you go along to your union and say, this is my evidence. And they go, you've got to do PEDA claims, whistleblowing claims. Now, obviously, I don't know anything. Back then, I knew nothing about whistleblowing and thought Edward Snowden when you said whistleblowing rather than anything else. So I said, let's do whistleblowing claims if that's what needs to be done. And then 5 days before deadline, my British Medical Association union pulls out of the case. A key document from the NHS investigation gets lost. And then my BMA rep gets lost. Undeterred, I go into the City of London and find a law firm to take the case, and because my evidence is so compelling, they do. And then I turn up to the London Self-Employment Tribunal. And you can imagine this, I've been doing A&E locums at night, because that's the only kind of place that will employ me, around London, just to keep my wife and my kids and the mortgage paid. And then the big day comes, February 2015, I rock up with my team to London Self-Employment Tribunal, ready to argue about my case, argue about the safety concerns. And you will not believe what happens next. Instead of engaging with the facts of this case, over £100,000 of your hard-earned taxpayer money is spent arguing me and all junior doctors in the country out of whistleblowing protection. And the case is chucked out without a hearing. This is weeks after Mid-Staffs, the Francis report, this happens to me. Now, the plan obviously for me was I go away and never to speak of this again. But what we did instead was launch a crowdfunding campaign to expose this. And I just want to show you this slide because I think this is important for everyone to understand. They argued these junior doctors out of whistleblowing protection 3 ways. And the first most worrying way is they argued that our Parliament consciously chose to exclude all junior doctors from whistleblowing protection. That is essentially a statement that's not true. And that was essentially what their case was founded on to stop this case being heard. And we were able to go to the Court of Appeal. And we were... Oh. Thank you. So we were... It's quite crucial, my evidence.
I'm sorry, I don't know what to do.
Yeah. So we were able to show the Court of Appeal evidence from Parliament about exactly what the politicians had in mind for PEDA, and it's a terrible law, and we're piling on at least that part of what she said. Not everything she said, I can assure you. And there is no way our Parliament decided that the entire medical profession below consultant grade was argued out of whistleblowing protection. So if I send a transcript to the Court of Appeal that shows that not to be the case, surely that is a very serious matter. If you add to that between £100,000 and £200,000 of your taxpayers' money being used to advance such flawed arguments, essentially to stop my case being heard for 4 years, we really do have a situation where politicians and people at the top of these NHS agencies should have to account for that. So in May, when all this came out, May this year, you'd think that's what would happen, but what happened instead was they paid me 55 grand and it all got brushed under the carpet. And that's really what I wanted to say, is that that's a real manifestation of the problem that you're going to hear from all of these people. You can see the passion in Eileen's voice she's heard story after story of what this actually means to people's lives. But I think what I bring to the table is a rock solid example that really society should use to bring about change. Thank you.
I'm Stevens, and advisor to Bank Confidential here on behalf of the founder, Mark Wright. And key issue we'd ask people to consider is why is free speech and people being able to speak freely and safely in financial services so important? People talk about 50 billion being used to bail out Lloyds and RBS at the time of the banking crash. People then talk about further 42 billion that was used to support RBS in buying shares and keeping them going with liquid funds. But the reality is the true cost of the crash to the UK PLC was around about 1.4 trillion, with funds that were put up and guarantees and bad debts that were bought out by the government. Many years on, still a lot of that money is outstanding, and experts would say that the real cost to the economy was maybe 2 to 3 trillion, with the knock-on effect with businesses and losses of employment with SMEs. Yet despite those losses, despite the fact that the UK was almost brought to its knees by the bankers, not one senior banker, not one bank director has ended up facing criminal charges or in prison. Compare that with Iceland, where you have a country the size of a London borough and 26 senior bankers are in jail or were sent to jail for what happened. So why do so few bankers face repercussions in this country? Well, the problem is there's evidence out there to criminal behaviours in the banks. We have some ourselves, and there are witnesses to the criminal behaviours, but people just don't speak up. And why don't they speak up? Well, the problem is that when you speak up in a bank, if the problem is big enough and it costs enough, rather than being supported, you will end up having your career ruined and your life ruined usually. Most whistleblowers I've met from the banking sector end up leaving the banks with mental health issues and losing their careers entirely. This is what happened to Mark. Mark was an advisor at RBS in 2008 around the time of the crash, and just days after Lehman Brothers collapsed, the directors of RBS, including Fred Goodwin and Chris Sullivan, put out a statement on the internal intranet telling the advisors to reassure staff and customers that all was well. The bank was well capitalised. Well, of course, the advisors did that, and they told many of their staff who advised numerous branches that everything was fine. The directors had said that the bank was in a safe position. Well, at that time, in reality, the bank was negotiating its bailout with the Bank of England and was not just undercapitalised, but substantially insolvent. So after that happened, and obviously people kept the shares, at the time the statement went out, share prices were just over £20. That statement stayed on the internal intranet for 6 months, came back off again in January 2009. By that time, the share price had plummeted 90%. The share price was just over £2. Now, some of the staff who were loyal to the bank had hundreds of thousands of pounds in share saves. There were 160,000 staff at RBS at that time globally, and we believe about 80% of those were shareholders. So Mark raised this repeatedly with his line manager at first, and then went all the way up to the directors and the board of RBS. Knowledge about that statement was denied. The statement was blocked from access to staff in January 2009. They were told they couldn't find the statement. The chief executive and the chairman of the bank stood by general counsel that no statement existed. And Mark ended up leaving the bank in 2013. He had a grievance procedure and he wanted that statement as part of his grievance procedure. And again, all his internal communications, which included that statement, were withheld from him. So he was pushed out of the bank until he was not a whistleblower. Mark then went to the FCA and he went and straight away exposed what happened and told them about the statement. His MP, Norman Lamb, backed him in doing this, but within weeks of him going to the FCA, nothing had happened, and Norman Lamb chased the FCA to say, what action have you taken? The FCA at that point immediately got in touch with RBS, they named Mark, and they said they believed at the time he still worked at the bank, they named his allegations, and they asked him if it was true. So if Mark had been worked there, he would have been exposed immediately by the FCA. And then what happened after that, they then came back to Norman and Mark, the FCA, and said RBS had not found the statement and they had no reason to disbelieve them. What happened last year when we brought a complaint over Mark being named as a whistleblower is we won the complaint, and the Complaints Commissioner had obviously received a file of documents in terms of investigating the complaint, so we did a data subject access request. And in there we found internal emails showing that the FCA had found that statement back in March 2014, and had continued to lie to both Mark and his MP about its existence. They even went so far earlier this year as to say that the statement was out there in the public domain and was known about, and it was one made by Fred Goodwin, and it had been given to the Treasury Select Committee. We now have direct evidence from the Treasury Select Committee that that is not the case. The upshot here is, if you're a whistleblower in financial services, not only do you face the end of your career, you cannot trust the regulator. The regulator is conflicted. He's too busy looking after the banks. Andrew Bailey wants to be the next governor of the Bank of England, and he will do anything to protect RBS to make sure that happens. That is what you're up against. You're up against the system, and you're up against the government. I suspect that's probably true in most other areas. That's why we need a change here, because there is no protection for whistleblowers. Whistleblowing systems are early warning systems that protect the banks, the NHS, whatever other employers are out there. And PETA has to be changed now. There has to be a difference made, and whistleblowers have to be properly protected.
Just to say that when people say PETA, what they mean is what's called the Public Interest Disclosure Act, a law that was passed in England in 1997 or 8, and it's understood as a law that doesn't work very well. Mary.
Hi, I'm Mary Inman, and I am going to kindly ask Chris to advance slides for me. He's been kind enough to do it. I'll tell you when. A little bit about me. So I'm a U.S. lawyer. I am only U.S. qualified. I'm not U.K. qualified. I have spent the past 23 years representing whistleblowers under the American Whistleblower Reward programs, of which there are many, and of which I'd like to sort of inform you today. So to start, the question posed to me was, tell us about the past, whistleblowing in the past. Well, the whistleblowing in the past in North America is something that I'm proudly able to say is something that's pretty old. So if you can show the slide. We first started using a whistleblower tool, an enforcement tool, and I'll describe that more, in 1867. It was known as Lincoln's Law, and we borrowed it from England. So this comes from English common law, and it's something that cheeky Americans borrowed from England, and then now we're trying to export it back to you. So it starts in 1867, and if you advance the slide, it was enacted with an idea that who has the information that can help the government recover monies that have been stolen from the government. So it was really a direct result of, during the Civil War, defense contractors were selling gunpowder cut with sawdust and lame horses to the Union Army. And the notion was, qui tam is what it comes from, and it's Latin here that says, he who stands in the shoes of the king as well as himself. So the qui tam device, which we shortened to whistleblower, basically means that we have taken from England a notion where you can deputize a whistleblower to actually bring a lawsuit in the government's name. So they can bring information if you know that, for instance, Boeing is selling helicopters to the Defense Department in the United States, and if you're an engineer at Boeing and you know that the helicopters are unsafe or that they failed testing and things like that, that's a perfect case where you could bring a case as a whistleblower and launch it in the name of the government. The case is styled whistleblower's name, so it would be Mary Inman, ex-rel, the United States, and then it would be versus Boeing. So it's a really powerful tool, and we've had it for a long time, but we took it from you. So flash forward, in 1986, the U.S. military, if you can actually go back once, Chris. In 1986, there was amendments to our False Claims Act. That's our original whistleblower statute, and it has really taken off since then. It was, at that point, defense contractors selling $600 hammers and $800 toilet seats to the government, and that was part of the reason for doing it. So keeping with the past, flash forward, in 1986, amendments were adopted, and because the act was so successful in protecting federal dollars, there are 30 states and 6 cities who now adopted their own False Claims Acts, which allow them to protect state dollars and city dollars. So it's based on the success of the Federal False Claims Act that all of these states said, we should do this too. So let me tell you a little bit about the success. So just a little bit on the numbers. The next slide will show you that between 1986, when our act was basically amended and reinvigorated. To 2015, over $47 billion has been recovered as a result of whistleblower-initiated lawsuits. So, and just in 2016 alone, the U.S. government recovered more than $2.9 billion because they were given information that was provided to them by whistleblowers. So moving forward, here's just a list of the 31 states who've adopted similar legislation. And here's some of the cities on the next slide. Okay, and you can go forward. Thanks. So that was so from 1867, from Civil War to present, that was one of our primary ways of using whistleblowers, is using whistleblowers as enforcers. So they are deputized to bring lawsuits in the government's name. So that has been our most successful program, but flash forward, starting in 2006, I talk about what we call our agency era, which means that a bunch of United States agencies have said, wait a minute, that whistleblower tool, that enforcement tool is so powerful, we should use it too. We want to receive information from people on the inside who can reveal where all the bodies are buried, what the unscrupulous contractors are doing. We want to know too. And we will set up what is called an Office of the Whistleblower inside each of these agencies. So starting, and if you can go back one more, Chris, starting in 2006, the Internal Revenue Service, our version of HMRC, adopted a program where if a whistleblower brings a tip to the IRS, it goes to the Office of the Whistleblower. If it has to show evasion of U.S. taxes of more than $2 million, but if you're able to show that, then that information goes to the IRS enforcement folks, and they take action based on your information. So the whistleblower's information doesn't just go into the ethers, it goes directly to the hands of the people who could do something about the wrong. The SEC and the CFTC, following the financial crisis, that was our response to the financial crisis. Our never again moment was to say we're creating an Office of the Whistleblower inside the SEC, because what had happened is we had a whistleblower who went to the SEC in Boston multiple times and said Bernie Madoff's company is a Ponzi scheme. He said it multiple times. His name's Harry Markopolos. And nothing was done with that information, which is actually the current state of events in the UK at this moment. Information goes nowhere. And so as we're coming right out of that, we said, no, we're creating an Office of the Whistleblower so the Harry Markopoulos of the world can bring their information forward, and it has to be acted upon after it's investigated. So that has been such a powerful tool, and it's been a very successful program, that we have one more, if you go back just two more, that's okay, that is most exciting for us. If you go all the way back. Keep going, sorry. That the Department of Transportation, as a result of a Takata airbag scandal, has just decided that they want to use a similar tip line. We actually represent the Takata whistleblowers who blew the whistle on Takata, which made defective airbags, which have caused over 24 fatalities to date. And our whistleblowers were the insiders in Takata at the R&D department who were saying that what you're deploying in the airbag, basically the ammonium nitrate you were using, is used for open pit mining. It has no business being in front of passengers, and he was fired for doing this. But he was able to bring that information to the DOT, and they imposed $1 billion fine on Takata and put them into receivership. So that's the power of the information. So we keep expanding our agency programs because the SEC program has been so successful, IRS, now DOT. But it's not just the United States. Canada, so we can go to other Commonwealth countries, Canada has similar programs on the back of our SEC program. They adopted for the Ontario Securities Commission, basically a similar program. If you know information about tax accounting frauds by companies traded on the Toronto Stock Exchange, you can bring that information forward. They also have an offshore tax informant program where whistleblowers, if they know of tax, think Panama Papers, Paradise Papers, if they have information about people hiding assets abroad, offshore, then they can bring that information forward, and then those people will be prosecuted. So that's the past for us. That's sort of bringing you up to date in sort of how whistleblowers are used in North America. I'm only going to take one more minute and slide you over to the UK. So if you can keep skipping ahead. Keep going. Right here. So that's the past in North America. The past in terms of what does whistleblower programs look like in the UK, this is one of the few places where you look back at the United States and we go back to 1867. It's one of the few times we can claim history here. In the UK, it's 1998 when we first saw a whistleblower protection statute. And that's the PETA Act, which is now 20 years old. And what I think the fundamental difference between the US model, the North American model, and the UK and European model is that I say that their model, the UK and European model, is reactive, which means it's only there to protect the whistleblower after the fact. After the whistle has been blown, they will protect you from retaliation. But it doesn't give you the second thing that whistleblowers want, and the most important thing that many whistleblowers want, in addition to protection, is they blew the whistle and had a message that they wanted to have heard, but no one heard it. The information goes nowhere. So the North American programs create offices within the enforcement agencies that require them to act. So I sort of want to describe that that's the fundamental difference here. And if you just do my last slide, and then I'll turn the mic back over. So yeah, that's it, the one right back there, PETA. So this is sort of the contrast, that the past is, the whistleblowing concept is relatively new compared to how we've been using it in the US since 1867.
Thank you, Mary. Okay, so obviously we've run over a little bit there. From what I understand, now we're going to talk about the future. Obviously, one of the topics for debate seems to be the idea of rewarding whistleblowers or compensating them. Another one I understand is whether or not whistleblowing should sit in employment law, as it does at the moment. And one other question that I think everybody agrees on is what we do in a country where our regulatory agencies simply are not independent and have no enforcement powers whatsoever. They do all seem to sit inside government, and I think that whatever our views on other topics are, we probably agree on that. Eileen.
Firstly, in this country, thousands of people are abused every day, and there's no such thing as safeguarding. It doesn't work. The regulator for healthcare, the CQC, 47 whistleblowers lost their jobs because the CQC told their employer who they were. And believe me, if we set up an officer for the whistleblower, they'll be made up from the same rotten people and the same rotten pattern that is going on and on and on. I know from PETA, being the first person to use that case, I must say I'm amazed that it's supposed to be protection for whistleblowers, because you may as well stick a saucepan on your head and whistle. Our case, they told us that the abuse of vulnerable people, that killing people, that people with bed sores to the bone, people being spat at, dragged by the hair down the corridor, they told us, and it's actually written in the verdict, we hadn't considered the consequences to ourselves before we went outside and reported the abuse. And that is PETA. 90% of the 8,000 whistleblowers who contact our helpline can't even use PETA because they didn't save up before they reported the abuse, and no one told them that that's what it would be involved. So at the end of the day, we need to learn about accountability. And like you said, I agree. People should be in prison who have harmed whistleblowers or ignored concerns, because your life depends on it. And it's not about money. I think all whistleblowers should be equally protected. No one case is more important than the other. I don't think my case is more important than any of my whistleblowers. We are all the same, and we should all be protected, whether it's one girl who's working in a small corner shop, which wouldn't make any money for the US false claims, where she's reporting that vodka has been sold, that is dangerous, that's been manufactured by the owner of the shop. She should be equally protected, whether she's in a small shop or the chief executive of a big bank. All should be equal before the law. And I'm actually quoting from Tom Denham's book, The Rule of Law, because I think a lot of lawyers have lost their way. Law and justice are two very different things. And all whistleblowers want are not rewards, due compensation, justice and accountability, so the people responsible are held to account and they're not allowed to stay in the system and go on and harm others. The guy that we reported to is a CQC advisor on elderly care. That was the director of our company. And at the end of the day, if you'd like to see CQC paying tribute to him, the video is on their own website now. So that's the kind of thing we do. We take the abusers and the manipulators, and at best we fine them a few, million. At best, they should be in prison for what they've done. People's lives are on the line, and to be honest, I fight for whistleblowers because I see every day people that mirror back to me what I went through. Bupa asked me how much I wanted to keep my mouth shut, and I said, you don't have enough money to keep my mouth shut.
Chris?
Sorry, what's your name?
Eileen Chubb, Compassionate Care. Thank you. I've got some leaflets over there and that lady.
And we've got an ambassador.
I think this is an issue for the public to really consider what, as a nation, what we want to do about this problem, because it just keeps the scandals keep on coming. And so I'm with Eileen in the sense that PETA is obviously not working. So I'll give you this example. I'm a doctor. If I have my wallet stolen, I walk down the street, someone bottles me and nicks my wallet, I assume someone's going to be very interested in that. At least I'll go down to a police station and they'll take a statement. And presumably they'll do that in the next within 24 hours. But if as a doctor, as a healthcare professional, I go somewhere and say, there's people dying, there's unsafe practice and there's people unnecessarily being harmed, we call that an employment issue. And if I'm lucky, I might get that case heard within the year, if I've got enough money and I tick the right boxes. If I'm lucky, I'll go to an employment tribunal. And it won't be about the deaths, it will be about all the allegations that have been made against me that I need to try and explain. And if I want to explain them, it will be a lot of money. Now we, as a society, we make that choice. This is what we want to call this thing, an employment dispute. So, Eileen's described the agencies at the top and the people at the top. But I'll be controversial and say, actually, isn't it your fault? You allow this. This has been in the news every year for the last 20 years. We go from scandal to scandal. Do you want this stuff dealt with in an employment tribunal where only rich people can get it dealt with properly? The answer really needs to come from the public.
I think Chris and Alan have made some very valid points, and Alan and I were chatting about this earlier. I think I agree you can't have offices within the regulators. The regulators are captured by whether it's the banks or the NHS companies or the private care companies. You've got to have independent people regulating this. And the biggest issue we've seen is the regulators will build their rules to get around PETA. In financial services, people don't realise this, but when you go to either the bank or the FCA, the regulator, as a whistleblower, you're classed as a potential whistleblower. You only ever become a real whistleblower if you lose your job and then prove that you've lost your job because you've been a whistleblower and what you've raised is in the public interest. If you do that and you win your tribunal and an employment lawyer says that you are a whistleblower because it was a public interest disclosure you lost your job over, at that point the financial services company has to report that to the financial regulator, the FCA. The regulator won't tell us about one single case being reported to them. We don't think there's one financial services whistleblower in the UK at present since the new rules came in 2015. The rules are designed for the whistleblower not to be protected. So you cannot have something within those organisations, you've got to have something independent. We also I spoke to Eileen earlier about the reward side of things. The rewarding is a dangerous side of things. I'm not anti-people winning money if they are brave enough to speak up. The way we view it is that people should be indemnified. Why should a whistleblower like Mark in his early 40s lose his job when he was earning, say, £100,000 a year and maybe never work again in that industry, lose his home, lose his pension that he was working towards? These people should be indemnified so that if they are brave enough to speak up, they shouldn't lose that income they would have had. And that's what needs to be looked at. We think that these people need to be properly protected indemnified. And the other big thing is anonymity. People think they've got anonymity. The FCA went straight to the bank and named that. This is what they do. This is how the regulators work. They collect information to protect the banks, not the other way around. They talk about anonymity and confidentiality, but under the Financial Services and Markets Act, you have no right to anonymity. The minute you have named yourself to your line manager or to a bank director or to the FCA, you are named. They'll talk about it being kept confidential, but they'll share your name with whoever they choose to from that point going forward. People do not realise the risks in speaking up. We have to find a way to not change the PIDA Act, to completely replace it with something that works.
I think what's important to, just in terms of talking about the future, and where I would like to see improvement. In the UK right now, you can certainly disagree that there's no place for the information to go. So let's leave to the side, let's make this the enforcement piece of it. Let's leave to the side the retaliation piece. There are horrible things that happen to whistleblowers, but that only is one piece of the equation. They blow the whistle and they are retaliated against, but they blow the whistle and it's shoot the messenger, don't listen to the message. So when you listen to the message, it's not just enough for the media to listen to the message, it's that the enforcement entities, so the FCA, NHS, other folks need to be able to listen to the message. So I understand that right now you have nothing. So I would argue starting with an office of the whistleblower inside any of these entities would be one good way, and then maybe there's a superstructure. There's a regulator, an independent regulator who regulates the regulators. But to this day, what the problem that we have is that there's no pressure for enforcement people to actually take action based on the whistleblower's information. Isn't that why they blew the whistle and got retaliated against in the first place? So that's one thing I think is really important, is the enforcement piece. And I feel like protection is equally as important, and PIDA is 20 years old and certainly needs a lot of work and a lot of help. But what is being entirely ignored in this country is not the protection piece that could be fixed, but nothing that says whistleblowers deputize themselves and can help become the enforcers. And it's exactly what you do in the law enforcement, right? We pay informants in law enforcement to bring information to us. So taking on the question of rewards, I don't disagree with an indemnification idea. Yes, in the United States, in North America, but also in South Korea and parts of Africa, this is not just an American idea. The notion of paying what can be described as rewards, the reason they're described as rewards is they try to give a whistleblower more than just the damage that has been suffered by them by that one particular employer. What the rewards seek to do is that you are now going to be blackballed in your career for your life. You need a quote, call it a reward, I call it compensation. Who in their right mind is going to take on RBS and not work for the rest of their lives if there isn't, or whose spouse, when faced with this option, is going to say, we want you to do this, without knowing that there's no safety net. So you can call them bounties, I call rewards safety nets. They're there to give you the things that are not covered by PIDA's damages, which is lifelong loss of employment. How about the health effects? That's not covered by PIDA. There's a New England Journal of Medicine study that talks about the increased incidences of divorce and alcohol abuse and other substance abuse, all these problems from the problem of being a whistleblower. So those things need to be compensated, and that's what the rewards seek to do. So I'm obviously a strong proponent of rewards, compensation, indemnification, however you want to call it. I call it a safety net. It is something there to capture what's missing.
Thank you. I think we find ourselves smack bang in the middle of information politics here. The information has to go somewhere, and at the moment it tries to travel, as you can hear, from whistleblowers, and very often those people who try to blow the whistle get hung out to dry. Chris said he wanted to say something, so I'm going to give him the mic, and then afterwards we'll start bringing in people in the room. So if you've got anything to add, then get ready.
I would just say, I on the rewards thing, I'm on the fence. I'm on it, which might be controversial. But there needs a lot of people do not want to whistleblow. The vast majority of people keep quiet. That's, I think, what we're missing here. So when whistleblowers do speak up, they're not supported. They're not just got by the people from above. They're not supported by the people around them. So actually, a lot of people would say, well, I'm not a do-gooder. I'm not a saint. I'll help if it works. I'll stop wrongdoing if it works for me. But if it doesn't, forget it. It's that person that the reward system could actually help, because all you get is people on their own, very, very isolated, actually not getting the job done at the moment. I haven't made my mind up, but that's what my initial reaction is to. I can see the passions, both sides of it. I don't think maybe either has the right answer on this.
Yeah, sure. Eileen, and then we'll come in.
Like I say, our report on Edna's Law is up on the website. It compensates whistleblowers for the loss of earnings, the long-term damage, and the rife blacklisting. So it does all of those things, but it does one crucial thing that PETA doesn't do. It holds to account those who committed the wrongdoing for the prison term, and that is a deterrent. And it's also an encouragement to other whistleblowers that they will be safe. And it also, like I say, has a groundbreaking element of public interest. Currently, we have judges in this country who can't define the public interest. So we have defined it. So I urge people to read this report and spread the word about it. Because at the end of the day, PETA was brought in by the charity Public Concern at Work. We contacted them as the first PETA case, and they did not want to help us because our case was an embarrassment to their poorly written law. And at the end of the day, that law, PETA, it was really written to promote policies and procedures in the workplace. It wasn't written for a courtroom, and it's crap in a courtroom. And that is the reason why. But unfortunately, Public Concern at Work's biggest income comes from selling those policies and procedures. I don't get paid for doing what I do. Our charity runs on less than $10,000 a year, which is the price of a cleaner in other charities. We do what we do with no conflict of interest. Edna's Law gains me not a penny. And that is why it's important that those who write the law are those who've been on the receiving end of the injustice.
Thank you. Could you put your hand up if you want to say something?
Hello, my name is Michelle Sweeney. I was a probation officer who spoke out as the privatisation of the probation service happened. I didn't know what a whistleblower was. Twice previously, I'd raised issues as a probation officer, and the company had to deal with what I was raising internally. So as the privatisation happened, I knew that risk could not be managed. I knew that it was ideological, and as a frontline probation officer, I knew that it just could not be split in the way that this was the government who was imposing this. So who protects those who are standing against the governments who are enforcing these practices through? I knew people would die. I knew it was preventable. I knew it was predictable. As I spoke out, I'm registered blind. I was a self-litigant. I went through 4 years. Now I'm coming into tribunal. The only person that has ever helped is Compassion in Care. They made me no false promises. That they knew that the law would not protect me. They knew the law and what I was raising would not be addressed. So how do you quantify a human life? How much does a human life cost? We've just heard 2 weeks ago that it's going to cost, not the government, the UK taxpayer, £500 million to bring them contracts back early. So 2014, when I spoke out, my life was destroyed, my health was destroyed, my vocation, everything that I'd worked for, that my husband had worked for. It's not compensation we need, it's a law. It's the law that protects us. It's a law that holds to account those who persecute, those who speak in the public interest and protect. So I understand to some extent a slight rationale, but no amount of money in the world would ever have compensated me for the people who have died. predictably and preventably. Nothing, not £1 million, not £10 million would have done that. The only thing that would do that is a law that stops it from happening and protects those who speak up in the public interest.
Who's next? Anyone else? Peter?
Hi, my name is Birgitta. I am a former Member of Parliament in Iceland, and I did a lot of work in relation to trying to figure out how to make a proper whistleblowing act in Iceland, and we are actually finally doing it. But I just wanted to ask, because obviously things are so broken here. They're also really fucked in Iceland. And they're also fucked in the States. Because, my dear friend Chelsea Manning was really beaten down by, one of the most courageous whistleblowers. Snowden can't come back home. And I haven't heard anything about how do you keep, and I would love to hear that, how do you keep those that, blow the whistle on corruption within governments, within the governmental body, how do you keep them safe from being in prison for, Chelsea was supposed to be in a prison for 42 years, and Snowden can't get a fair trial. He cannot get a trial, with a jury. They're going to take him on espionage. So, and relative winner is now, all the laws are broken on him. So, on the one hand, I don't think any country has a perfect law or perfect culture to deal with this. And just like you said, people need to start to care. So how do we do that? Because it's not enough to have laws. Laws are false safety. If the culture allows this type of behavior to carry on, like this terrible treatment of old people and sick people, for example.
There's just one thing. With Edna's law, it's a people's law. It's written by whistleblowers. It's not going to go through Parliament because I don't negotiate. What we want is public outrage. There's a petition up for Edna's law. We want the people to support it. It's the only way to change it, because Compassion in Care won't negotiate with any government, and the House of Lords has to pass a law here where most of the companies and the people are represented in the House of Lords are on the boards of companies that have crucified whistleblowers. Is this democracy? No. And absolutely, I agree. Chelsea Manning, Snowden, they are a scar on the face of the American justice system. They've got no right to go anywhere and say they have whistleblowing laws whilst these cases exist.
I would also say that there's a real problem with the media. We put some information to the media recently about reviews that RBS are undertaking, where tens of thousands, if not hundreds of thousands of people are not receiving compensation on investment products, and the whistleblowers have gone to the FCA, they came to us, we put it to a number of news outlets. The media are not letting people know what's really happening in this country. The indirect taxes people are paying because of these corrupt actions that keep on going is huge. And the people who are paying the price are the actual taxpayers, but they're not aware of this. So we need media support to get this out there to the public in a way that helps them to understand the real cost to them of this whistleblowing system.
So I think it's really important that I think there's a reaction because we're American that we are rightly or wrongly perceived as mercenary and overly litigious. But what I would ask you to consider when you are conflating two issues with whistleblowing, okay? All the statutes that I just talked to you about deal with bringing private contractors who are the Carillions of the world, our version of the Carillions of the world, who are taking federal taxpayer dollars, state taxpayer dollars, selling unfair products. These are car manufacturers. All of those and the amount of money that we've been able to bring back to the public coffers, you are basically saying to me, by lumping that in, you're saying, okay, you're ineffective as to government whistleblowers who are blowing the whistle on the government's actions. You can leave that to one side, but don't throw the baby out with the bathwater. So I just think people conflate it. Absolutely. Are we perfect? No, we're not. But have countries around the world now, including Canada, South Korea, throughout parts of Asia, who are now starting to look at our types of models, including the Netherlands with a house of the whistleblowers. It does have validity. So I'm just saying, I just think it's important that people recognize the successes and not, and yes, that's another area for us to deal with, but just because we didn't, whatever you think about Snowden and how we handled it, it's very different from all of the programs I just discussed today.
Can I just add, I was talking about I was asking a question. I was not saying that the holding the corporate sector accountable is not working. I wasn't saying that. Okay. So please don't put words in my mouth. I was asking you about, the war on whistleblowers that are blowing the whistle on the governmental sector, on the public sector. Because everybody was looking at the States. I modeled, when I was putting the resolution forward in Iceland, I modeled it on the American, and then one friend after another was taken down by the government for trying to do the right thing and blow the whistle on crimes. So where are you at with that?
So that's not I've spent 23 years exclusively in
I'm not talking about you, I'm talking about the United States.
Can I just say something here? I'm not sure, but as someone who is, got a lot of respect for both of you, I think what you're talking about is crimes by the state, and that's essentially the opposite of what Mary does. So she's talking about consumer protection and taxpayer protection. So it's a different story. Sure. So what are you asking again? So yeah, please.
You're talking about the U.S. as a model,
yeah.
Right?
Yeah.
Only for private contracting.
Okay, only for private because we have people in the panel.
Only consumer protection. All of those programs I listed are all things that go after.
I'm just talking to the entire panel. We have people in the panel that have been reporting and blowing the whistle towards the public sector. And so it's a little bit confusing.
Sure.
And so
absolutely.
I just wanted to, I was just asking a question. Where is the United States at when it comes to protecting whistleblowers that are doing what the people here in the panel have been doing here in the UK? Because it's very confusing if you're talking about, getting money into the coffer from whistleblowers.
Sure, yeah, exactly. It's like two sides of the balance sheet, isn't it? If something's been privatised, then you're talking about saving money when private contractors are ripping the government off. You're talking about what happens when the government are doing the crime. Sure, good question. Can we have a question from the lady at the back, and then Chris, and I think we've got probably about another 5 minutes left.
I think there's a sort of danger that all we're saying is we don't protect whistleblowers. I think as an NHS person, doctor, I'd say that a lot of energy and a lot of money is spent shutting whistleblowers up. I can't think, as I said before, of a better objective example than our Court of Appeal case, where £150,000 of your taxpayer money was spent arguing all junior doctors out of whistleblowing protection. And I just think that is a rock-solid example of how the NHS and the public sector uses your money contrary to all of your interests. And it just, there's many other examples, but it really is a question for the public to think, is this what we want our money spent on? And to do something about it.
I'd just like to address what that lady said earlier on. There's two kinds of whistleblowing in this world. There's the whistleblowing that's convenient, and there's the whistleblowing that's inconvenient. And Chelsea Manning was inconvenient. And we should not forget what America did to these whistleblowers. As a whistleblower myself, we actually supported Chelsea in any way we could, and we rang the White House and asked for clemency. And I'm proud to have done that. And we stand with whistleblowers across the world because whistleblowing crosses all barriers. However, Edna's Law is what would hold people to account, because people who harm whistleblowers go on to harm other whistleblowers. And if you do not deal with them by putting them where they belong in a prison cell, they will continue to do harm. So it's not just about the money and what is spent, because every case is important regardless of background. However, what we have in this country is regulators who pay tribute to known abusers and then say that they're standing up to protect people. At the end of the day, do we want these people in charge? Do we want another office for the whistleblower?
Hold on, Eileen. Regulators do exist, for good or for bad. As it turns out, they've got no...
Who's regulating the regulators?
Yeah.
We are. 52 stories in Private Eye about regulators' lies and scandals. 52 stories.
Eileen, it's not as though there's anyone in this room that's going to disagree with you on the fact that we've got a problem with regulation in this country. If you can find someone here that says regulation's perfect, I'll be impressed.
However, regulator's not the answer.
Yeah, but just to say...
The law is the answer.
Yeah, but you do realise, okay, once I remember being in a room in Brussels a few years ago because I was there for a TTIP event, and the semantics of regulation in itself, no one understands what it means. Is it law or is it a regulator that's supposed to? Who actually says that's a crime?
It depends on whether it's convenient or not.
Who's going to enforce the law?
No.
You're saying this is your demagoguery, populist stance. Yes, I'm in charge. We're going to do it like that. But who's going to enforce the law?
Read Edna's law.
Who's going to enforce the law?
The police. Who else would investigate crimes? We don't need a regulator on murder. Murder is a crime. Well, we just have good practice and
I'm
guidelines.
talking about corporate crime as well.
No, all crime.
Yeah.
All whistleblowing.
So corporate crime's included.
Yeah, all whistleblowing.
Hello. Are you talking about regulators? My regulator that I blew the whistle to was awarded a CBE. It's a CBE.
Yeah, but we're not
and she pretended she didn't ignore me, but they are appointed to regulate. And you're asking, you said yourself, regulators need regulating. So then you have another regulatory body who's not going to do anything, and another regulatory body who's not going to do anything. And then we award them all OBEs, CBEs, whatever it is. And then you're gonna. I was in this one. All they ever asked my whistleblowers was, "How much will you settle for?" That's what we were here for. That was the only question I was asked. How much will you settle for? That was literally within our emails.
Panorama protected her.
I think that it's a combination. That we go back to the regulation law. The FCA do have enforcement powers. They can take criminal action against bank directors that choose not to. The issue is, so there is regulation and there is law, and it doesn't work, and it doesn't work together. And it doesn't work together because the regulators work around the law to support the people that are supposed to be regulated. They both need to be worked on, but we need independent bodies acting for whistleblowers, nothing to do with the organisations. It's the only way things will ever change.
Okay, that's it.
The CQC is an independent regulatory body.
So, yeah,
So is the FCA, but they do everything HM tells them to do.
How can you have another independent regulatory body when you already have one?
No, it's about making it independent.
You can't make it independent because it's the same people at the top of all of these organisations. They just shift round from one area to the other. We need to get the lot out.
Thank you, everybody.